Welcome to the YouTube channel of Legally Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's video we shall discuss about advisors related to equity offering. An IPO of equity shares on the main board of a recognized stock exchange is a standard primary listing mechanism in India. The IPO process involves a number of intermediaries, advisors, and third parties, and the key personnel are outlined below. Merchant bankers. Under the SEBI Issuer of Capital and Disclosure Requirements Regulations 2018 ICDR regulations, the issuer must appoint one or more merchant bankers registered with SEBI and designate at least one of them as the lead. The merchant bankers are the gatekeepers of the IPO and have overall responsibilities for ensuring true, fair and adequate disclosure in and otherwise completeness of the offer documents. To this end, they undertake the following activities among others: due diligence and documentation, managing procedural and logistical issues, recommending and coordinating with other intermediaries, interfacing with the SEBI and the stock exchanges, publicizing and marketing the issue, advising the issuer as to the appropriate pricing and timing of the issue, underwriting the issue. Typically, the issuer enters into an agreement letter with each merchant banker that sets out the responsibilities of the merchant banker with respect to the issue and specifies the fee structure. However, if a merchant banker is also an associate of the issuer, its role is limited solely to the marketing of the issue. Under the ICDR regulations, the issuer and the merchant bankers enter into an issue agreement typically immediately before the filing of the draft red herring prospectus, that is DRHP, with SEBI. After receiving SEBI's observations and closer to the red herring prospectus filing date, the issuer, the merchant bankers and other syndicate members, typically the broking arm of the merchant bankers and other brokers, enter into a syndicate agreement in relation to the marketing of the issue. The issuer also enters into escrow agreement with the intermediaries for collection, appropriation, processing of unified payments, interface mandate requests, and refunds of monies, among other matters. On finalizing the pricing date, the issuer, merchant bankers, and also syndicate members enter into an underwriting agreement which records the details of the underwriting arrangements between the merchant bankers and the syndicate members. Legal counsel. In most IPOs, the issuer and the merchant bankers appoint their respective Indian legal counsel. In addition, if the offering is marketed to investors outside India, which is often the case, the bankers typically appoint one or more international legal counsels to advise on matters such as disclosure requirements, publicity, marketing, selling, and transfer restrictions. Taxation in the foreign jurisdiction. Legal counsels are collectively involved in the due diligence process and documentation, including the drafting of DRHP, RHP, prospectus, and various transaction agreements. Drafting and advising on publicity and research guidelines. Advising on comfort letters from the auditors. Generally, advising on legal matters pertaining to the issue. At specific stage of the IPO process, each counsel issues legal opinions in connection with the issue, addressed to and for the benefit of the merchant bankers. These opinions are critical as they help the merchant bankers establish a due diligence defense with respect to the contents of the offer documents if required. Auditors. The ICDR regulations require the historical audited financial statements of the issuer for the preceding 3 fiscal years to be restated in accordance with the prescribed format and presented in the DRHP, RHP, and prospectus. As a result, the examination report from the auditors of the issuer in relation to the restated audited financial statements is an important document for an IPO. The DRHP and the RHP also contain a significant amount of information that is extracted or derived from the issuer's financial statements. The auditors review the financial statements and provide the comfort letters addressed to and for the benefit of the merchant bankers. Whenever necessary, third-party chartered accounts valuers can also be engaged by the issuer to provide independent certifications. Registrar to the issue. Due to the large number of bids received in an IPO, it is essential to appoint a qualified and capable registrar to the issue. The RTI manages a host of pre-issue and post-issue matters, which involves processing a substantial amount of data. The RTI, among other things, is responsible for processing applications, data entry, allotment letters or refund orders, preparing refund data, redressing investor complaints, etc. The issuer enters into registrar agreement with the RTI before the DRHP, which encapsulates the obligation of the RTI both before and after the IPO. In addition to the above advisors, various other third parties and intermediaries can be involved in an IPO, including an advertising or public relations agency, a professional printers, self-certified syndicate banks, banker to the issue, a monitoring agency. Hope this video is informative. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.